5 seconds. The learned counsel for the petitioner submitted that there was no irregularity in the publication of the auction and consequently the auction could not have been cancelled on the sole ground that the consideration as inadequate. The learned counsel further submitted that assuming without admitting that the auction could be cancelled on account of inadequacy of the consideration, in that event, before cancelling the petitioner should have been given an opportunity to revise his bid. Further, the learned counsel submitted that the impugned order cancelling the auction was violative of the principles of natural justice and that an opportunity of hearing was required to be given, which was also contemplated and provided under Rule 115S of the UP Jamindari Abolition and Land Reform Rules 1952. In support of his submission, the learned counsel has placed reliance upon a decision of the Supreme Court in Ram and Shyam Company versus State of Haryana and ORS 1985 3 SCC 267, wherein the learned counsel placed emphasis upon the observation made by the Supreme Court in paragraphs 13 and 18 of its judgment, which provided that an opportunity ought to have been given to the petitioner to improve his bid when his bid was rejected on the ground that it did not represent the adequate market consideration. Having heard the learned counsel for the petitioner and having perused the counter affidavit filed by the state, the court is of the opinion that the submissions raised by the learned counsel for the petitioner is patently misconceived and bereft of merit. The judgment cited by the learned counsel is not applicable to the present facts and circumstances of the case. In Ram and Shyam Company Supra, the Supreme Court found that the petitioner's bid was the highest but was rejected on the ground that another competitor arbitrarily gave an enhanced bid subsequently. It was in that light that the Supreme Court held that an opportunity on hearing should have been provided to the petitioner to enhance his bid, but this is not the case in the present scenario. In the present case, the bid has been cancelled by the state authorities on the ground that the bid was inadequate. No doubt detailed reasons have not been given in the impugned order, but the counter affidavit reveals the ground for cancellation of the auction. The state has come out with the stand that the High Court had delivered a judgment in which the court had directed that the fisheries lease in future should be granted at the minimum rate of Rs 10,000 per hectare per year. This judgment was delivered prior to the advertisement issued in the present case. Since the direction of the court was violated, the advertisement itself became incorrect. The reasoning given by the authority in the impugned order was correct, namely that the bid was inadequate through detailed reasons were not given but that become immaterial since a direction of the court was not followed by the authorities.